p.m. Monday, January 12th, and you know we're on YouTube, so we have two cameras, one here, one there at the podium, so when anybody speaks, please be aware of that and use the podium to speak. So first we need to call for order.
Rupert Friday.
Speak here.
James Grundy.
Here.
Stephen DeSimone.
Here.
Thomas Callahan.
Present.
Dr. O'Neill.
Here.
Mr. Vice Chair, you have 5 members present. You have a quorum.
Okay. So we have an administrative matter to clear up first before we get to the recommendation from town council, and the elect officers to this committee. So we will open the election for the chair.
Move Tom Callahan to the chair.
Okay, I think I can second that. Robert's rules. So that's seconded.
Yep.
Yep. All those in favor?
Aye.
Aye.
Right.
Aye.
Well, thank you all.
Yeah.
I think.
Congratulations.
So, yeah, there you
Or
go.
condolences, I don't know.
Yeah, or both.
All of the above.
So you want to take over from
Sure.
there? Or you want me to?
No,
Go ahead.
sure. So, the second order of business is the zoning ordinance amendment.
We need the rest of the officers.
Oh, pardon me. Yes. Thank you.
I move Dr. O'Neill as vice chair.
I'll second that.
You're another chair.
You're running me, Wilson.
Oh. all, all those in favor?
Aye.
Well, thank you, Will.
We need a secretary.
And now we need a secretary.
I move. Be secretary. We foisted on him again.
I will second it. Wow. Okay. All in favor?
Aye.
Abstain.
Congratulations.
There we go.
Oh, you are going to abstain? Okay.
4-1.
So you were going to move right along?
I
Take
am.
over. Okay.
So the second order of business is a recommendation to the town council regarding a proposed zoning ordinance amendment to section 9.1.2 regarding the non-conforming uses and structures. And the applicant here is Martino. I think the attorney representing the Martinos is Jack McGreen,
Yes,
and Mr. McGreen is not here this evening.
I do not see Mr. McGreen.
Do we have a phone number for Jack?
I do.
Do we need to call a short recess and see whether or not we can?
I would say out of courtesy,
Yeah.
just to determine that he's on his way or how long.
Can you do that, Jim?
Yes, I can call.
Great. So we'll be in recess till we figure this out. recess and back to order, please.
Hello?
Can we have your attention, please?
Back live.
We're back live, okay. So Jack,
That's all I want.
Hi. Apologize for that.
it's okay.
Little Triple A jump in the Warwick City Hall.
You got enough time to get
I do.
yourself together?
Yeah, I'm good.
Okay, Jack, so, you've got the floor right now.
Thank you, Mr. Chairman. As you may know, on my application I submitted, my client, Ms. Martino, has an application pending before the zoning board requesting dimensional relief to construct a new raised ranch in conjunction with demolishing her existing home on her property, which is located on a legal non-conforming lot of record. The zoning board has taken the position that pursuant to the recent July 18th Supreme Court decision in the case of McLeod versus the Wesley zoning board, the Narragansett zoning ordinance, which is similar to the Wesley zoning ordinance, does not permit an owner to demolish an existing house on a legal non-conforming lot of record without conforming to the dimensional requirements of the zone. More importantly, the zoning board has taken the position that it does not have the jurisdiction to even entertain the request for a house that is being demolished on a legal non-conforming lot unless the Narragansett zoning ordinance specifically permits the request for such relief. Excuse me, got my breath here. As you know, it's been the past practice of this board that demolishing an existing home on a legal non-conforming lot of record in conjunction with dimensional relief was consistent with the comprehensive plan. It's been the past practice, I would say, since I've been practicing before this board. I did draft a text amendment to section 9 that deals with demolishing of buildings. And I also reviewed Jill's staff report along with some comments from Wayne and a couple of other attorneys here. I think Bill Landry's here, and Steve Marcel is going to be showing up with some comments that he might have at 6:30. He said he'd be here. I did have a chance after reviewing Jill's comments to make a couple of revisions to my suggested text amendment. I'm not sure if you had a chance to receive those, but I did print out some copies.
We just got it.
They got them.
Oh, you got them?
Yes,
You have copies of everything? Okay.
yes.
And so I think one of her comments was I had dumped the language in the use section of section 9.1. Since then, I broke it out, I revised the definition, so it wasn't just considered, initially section 9.1 said non-conforming structures, and really even though it says structures, it also contains a provision in there for dimensional non-conformance. So I changed the title, I broke section 9.1 down into two sections. I moved section 3 of 9.1 into a new section I created called 9.1, 9.2 dimensional nonconformity. And I took that dimensional nonconformity language and I just dropped it down into that section. So basically, the intent of my modification is to give a person that has a legal non-conforming lot of record that wants to demolish that building, give them the right to come in and ask the zoning board for dimensional relief. And that's really the gist of my amendment. I know, and there's some other attorneys that I'm sure want to speak here today, there's some other matters pending before the zoning board that have been put on hold, specifically special use requests that have been put on hold. Especially as it relates to a overlay district 4.4. As you may know, anytime you go in for a special use permit and you're in an overlay district, chances are you need dimensional relief, like 168 feet of dimensional relief because you're in an overlay district and right on the water. So I don't think personally that special use permit is affected by that Wesley case. Others may disagree. Just on a side note, I think 4.4 should be completely removed from the zoning ordinance because I think CRMC has exclusive jurisdiction, but I'm not here to reinvent the wheel. I'm just here to get my client over the finish line so that she can build her a house and ask the zoning board for dimensional relief so that she can proceed forward. So with that being said, I can entertain any questions that the board may have. and, or I'm not sure if other lawyers have spoken yet, before I got here, but,
You're the first, Jim.
okay.
So, just procedurally, this board's being asked to consider making a recommendation to the council to change the ordinance.
Yes, exactly,
Thank
exactly.
you. Questions for Jack? Jim? No?
Still reading and
Yep.
digesting it.
Steve?
Same.
Okay. Bob, have you had a chance to look at this?
No, this one, the new
The new draft?
document, no, I haven't seen it yet.
All right. There you go. Anybody else care for a copy? Sure. $5 a piece.
We need one more.
Well, I'm trying to recoup my client's $900 application fee, so if anybody wants to give to the cause, we appreciate it.
Okay.
So Jack, how do, and I
This is the same.
I haven't absorbed the change you made from the old version to the one that came tonight, but how do the new dimensional standards for subdivision lots, I'm sorry, for substandard lots, should have my glasses on, interact with this section of the regulations for non-conforming development? It would seem to me that the new standards for substandard lots would make a lot of lots, the dimensional nonconformity disappear on some of them, right?
Are you talking about the on merging lot section? Is that-
No, the substandard lots, dimensional change in 2023 was proportional to the substandard.
Right.
So 5,000 lot in
Right.
R10, it's
Right.
already reduced by half your
Well,
setback.
that just sets, that statute just sets the setbacks for a legal non-conforming lot of record. What this case said is that even though, so you have your dimensional requirements for a legal non-conforming lot based on a proportionality. What Wesley case said is that if you have a house that's on that lot and you knock it down, you have to conform to those modified.
Right, the new standard.
You can't ask for a foot or 2 feet or 6 inches or height relief or far relief. You can't ask for any of that. You need to conform. So if you had a vacant lot and then you had a house, the person that has a vacant lot right now can ask for the dimension relief. But if you have a house on a lot and you knock it down, you can't ask for the dimension relief. That's what makes
the way it's written.
makes it a little silly,
Yeah.
the way the case came down.
And I guess, so I went back, I went through this a lot. And I went back to, I think you know that a lot of our zoning ordinance is verbatim from the enabling legislation. So I went back to the enabling legislation, and that's not the case here. It's enabling, and this is written. But it seems pretty clear that the intent was to have pretty high standards for redeveloping non-conforming lots. And I don't know if you have an opinion of what the origination of that was. I mean, that's what it seems like. If you read the language, it's, it's like continue the existing footprint. You can expand up to 25%, but not more non-conforming. I mean, there's a pretty high standards that somebody wrote intentionally when this was done 35, 40 years ago.
Right. Well, I suppose, we have setbacks, for example. But there's this other section of the statute that allows you for relief. And you have certain standards you have to meet. It's not a self-created hardship. It's more than a mere inconvenience, that sort of thing. I think everybody just assumed that that section of the statute should apply to the entire zoning ordinance. So, but the Supreme Court in that Wesley case stated no, this was, that specific section of the ordinance states that you must comply, and you can't use section 6, or section, variance, is it 6? I think it's 6. The
Jill
dimensional
knows.
variance, is it section 6?
It is.
Yeah, section 6, that you can still use section, they're saying you can't use section 6. And all the other sections of the ordinance, you can use section 6 if you're looking for some sort of relief. I personally think that, you know, if you read the comprehensive plan, I mean, it's the intention of the comprehensive plan to give people relief when they need it. And, you know, my instance, my client has an existing house. It's falling apart.
Yep.
It would be crazy to try and leave one small section of that foundation up to circumvent the statute, right?
Yeah,
So that really doesn't work towards the public purpose of trying to fix a new home, but you have to keep one wall up in order to circumvent that Wesley case.
Right.
So I think it's in the best interest of the town and the citizens of the town to allow them to raise houses without all of a sudden losing what they've had for like the last 40 or 50 years. I mean, if my woman's house is raised, my client's house is raised, she'd have to shrink it by another 2 or 3 feet on either side, and she wouldn't be able to get her, in this instance, her wheelchair down the middle of her raised ranch. So it doesn't seem to me that that's in the best interest of the citizens of the town of Narragansett, not to be able to ask for that type of relief.
So you read it that you can't even use the existing footprint, that's the way you're reading it?
No, if you demolish that home and that foundation, you have to conform.
Okay.
I did have a conversation with Wayne, and initially I continued my case, but they were looking for a structural engineer to come in and make a determination that the foundation, if we kept a portion of the foundation, which we would have had to dig it up, it just wasn't worth it, so that's why we kicked it over to see if we could get this text amendment through.
And then the other question I have is for structure. So in 9.1, 1 and 2, the relief is through special use permit, which is section 10.1?
No, it's just a regular dimension relief. I threw in there,
No, I mean, that's the way it's structured, the existing structure is, right? The relief, there is relief for section 9.11 and 9.12, but it's through a special use permit in section 10.
right.
So is there a reason not to use the same structure and have a special use permit?
Well, I mean, as the state enabling legislation states, you have to have objective criteria if you do want to have a special use permit. We already have criteria in the dimensional regulations.
Well,
Why-
there's also criteria for the special use permit here. Right, there's already criteria for section 10.1.
Yeah, but I'm amending section 9, not section 10. I'm dealing with dimension relief, not use relief. I think section 10 relates to use, correct?
It's alteration, so 10.1 is use, 10.2 is expansion of non-conforming, that's Galilee. Yeah, you're right.
It's use, right?
Yep.
Yeah. I'm just looking for dimensional
Okay,
relief. We
got it.
already have standards in section 6, so why drop another regulation, special use regulation on
Okay.
top of dimensional regulations?
Anybody else right now?
I appreciate you adding the special use permit and staff approvals as applicable in the new draft,
Right.
because I was also concerned about section 4.4. To be candid, I actually thought we were working on this at a subcommittee and it ended up just being 4.3. But I went through the GIS in the town. There's about a dozen lots in town right now that are waterfront lots that are 200 feet deep.
Right.
Every other waterfront lot in town can't comply, so they have to get a special use permit. So I'm glad you put that in there, because I was gonna bring that up.
Right.
So thank you for that, Jack.
And I did, I know Steve Marcellus was gonna be here. After I made my change, Steve was of the opinion that the language I removed and dumped down to section 9.2 should probably stay in section 9.1. I wasn't sure, but frankly, I was talking to him while I was driving, but that was gonna be his suggestion, if he was able to make the meeting, is that put the language I removed in section 9.1, put it back in for the use Again, I'm not, my person's more concerned about dimension relief rather than use, but, I have no problem with inserting that language back in if it's the staff seems that to be an appropriate addition.
Do you think that would be appropriate, Joe?
To add in, special use permits and,
Back into 9.1?
The language I had removed in 9.1, dumped it down into 9.2. I think Steve thought it should stay, it should be reflected in 9.1 as well as 9.2.
you're talking about involuntary demos,
Yes.
God of the public enemy?
Yes, I think that's,
Um, Well, I think an act of God or the public enemy or involuntary could occur in both use and dimensions, so it might be wise to put it in both.
right.
I have not, we just received this today, Mr. Eastman,
Yeah.
so
Yeah,
I don't have any comments.
Yeah, I don't
on
mean
it
to put you on the
until-
spot, I just.
Yeah.
No, I'm not, I just, I was talking to Steve on the way down, so, if he didn't get here in time, I told him I'd mention that. So, and I'm sure he can send you the language that he was thinking about and exactly where you would like it placed. But, I know as a practical matter, I have 5 other clients that haven't even filed applications because they're waiting for this language to go in. I think there's at least 10 other files that are in limbo until this gets resolved with the town.
So, just as a process matter, Jack, staff hasn't seen it, you haven't seen it yet, have you, Bob?
Correct.
Until now. It seems, and the board hasn't seen it until now, it seems moving on this tonight would be challenging at best.
Right.
I guess my question from a process point of view is this something, Jill, that we can hear tonight? If we were to continue it until our next regularly scheduled meeting in January, do we have room to do that? If we took testimony tonight from all the interested parties, we have the language, assuming it doesn't change between now and then, would we be in a position to act on it with any further dialogue that we need to have at that moment in time, based on what's on the agenda?
You have a public hearing on your agenda, you have another recommendation of town council on your agenda, and it's a regular agenda. You have at least 2 site reviews. You have an update for the zoning ordinance amendments, the ones that you've been working on. You have an update on your subdivision regulations. I'm not sure you'd be able to get to your entire agenda. Further, I'm not sure that the staff, if there is an inclination that the staff will be able to read this. Wayne hasn't weighed in, unfortunately he wasn't able to be here tonight, and to work either with Mr. Green or with the board. But we could just, so the deadline for next week's report is tomorrow.
So, we got an issue in terms of acting on this tonight,
Right.
and got an issue in terms of when we can get it next scheduled without doing a special meeting, I presume.
Well, yes, so at a special meeting would require a 48-hour notice, it's Monday.
No, I'm just saying a special,
Another
another,
So the deadline for this, for your recommendation is January 22nd. So something, either Mr. McGreen can give you an extension. We can certainly put it on the 21st agenda, but it'll be, I can't promise you, we'll get to it.
Okay.
We have.
so, talking to the other board members here, my inclination is not to act on this tonight without having council, staff, ourselves have an opportunity to review it more completely. I have no objection to continuing this discussion tonight in terms of people who come out for the meeting, the other attorneys that are here, and any member of the public that's here to provide as well. If we've got to act by the 22nd, Jack, and given what Jill's just said in terms of what our meeting schedule is like, you're going to put us in a position where we're not going to, I don't think we're going to be able to make a recommendation
Right.
that's going to be helpful to you.
No, I'm not.
You know what I'm saying?
I'm looking for a complete work product.
Right.
I'm not trying to shove it down anybody's throat.
Right.
My client she'd like to start building in the spring, so I'd like to, have it done sooner than later.
Okay.
But obviously, if you need more time, you need more time. I know, I got the everybody's working on this thing. I got Jill's comments on Thursday. Believe it or not, I have other clients other than this particular client, so I wasn't able to make the changes until this morning. It's pretty, nothing's easy, but basically, all we're trying to do is codify what this board's been doing and the zoning board's been doing for the last 20 years. So
And the
I don't
question
see
is
it-
whether the language will do that, and
Right.
are there any unintended consequences of
Right,
doing what we're doing?
no, I understand.
You know what I'm saying? That's really the
Yeah.
flip side of this thing,
Yeah.
so. That's my inclination, and then, I don't know that we need to schedule it right now, but maybe February, is it too early to be thinking about February?
The February regular agenda?
Yes,
You can put it on the February regular agenda.
Is this on down before the town council already? Has this been scheduled?
It is, I believe it's, right, so that's why we would need a continuance from you, Jack, so we could move it at the council.
So when is the,
I believe it's February 2nd.
February 2nd is a council meeting?
Mm-hmm.
It just meets once a month?
You meet twice,
Twice.
first and third Monday.
Okay, and then this could get set down before the second meeting?
In February?
Yeah.
No, because the planning board meets after the second.
Oh, so this is gonna go
Council
to March
meeting.
now? Okay,
Mhm.
all right.
I mean, the other option is the board can set a special meeting.
good.
Yeah, so Mr. Chairman, I feel like, to pick up what Mr. McCrean said, I feel like we want to think about this thoroughly. I think responding, he's looking at it through the lens of his clients. There's other attorneys here looking at it through the lens of their clients. I think it would be good to look at it holistically so we adopt a good piece instead of cookie cutter for each
No, I agree.
client's applications. So I don't know, process-wise, if we can create a committee of the board, subcommittee of the board, work with staff and council to take all the input and the different perspectives and also include the town's perspective, the town's interests. Anyhow, that's my thought on it. I don't know how others do it.
Well, or a special meeting, which essentially would do what you're talking about, rather than a subcommittee. A special meeting would accomplish the same purpose.
Well, I think there needs to be stuff hashed out to bring to a special meeting, is my feeling. I don't know.
No, it's more efficient, more fruitful. Do subcommittee.
Either of you have a
I'd
question?
like to hear from the other attorneys and other
Yeah.
people before we decide if we need a
Yeah.
committee or.
Okay.
Fair point.
Thank you, Jack.
Thank you, Mr. Chairman.
Okay,
Sorry for the delay.
somebody else want to be recognized? Please
Thank
introduce
you,
yourself.
members of the board. Bill Landry, I'm with Blish and Kavanaugh in Providence, and I want to thank the board and the town officials and the town council for addressing an issue of great importance in a very efficient way here and inviting the input of others on it sooner rather than later. My client's situation, like dozens of others that have been on the board agendas, various board agendas, and others that have gotten approvals and are in the preparation for building permits, there are dozens of properties that have been paralyzed through no fault of anyone here. All I see here is an attempt to try to balance this out and clarify and correct so that we don't have this paralysis. But there are millions and millions and millions of dollars of properties that are going nowhere. My client has been prevented from proceeding with a closing as a result of uncertainty. And they only need a staff approval. And for this same property, they've received 6 staff approvals since 2021. This is the Cedar Point property, the former Kenyon farm property, 69 acres on Salt Pond, there were 6 existing structures. They're only proposing to move those structures away from the water, pull them back, and have them be reconstructed, instead of doing just what Mr. McGreen suggested, which is to try to fashion something around the existing cottages very close to the water, looking like nobody wants them to look like, and being located where no one would prefer to have them located. So 5 years ago, and these 5 units, there's another existing unit that's not being demolished and reconstructed, but we're talking about 5 or 6 units on 67 acres here. The changes that have been suggested are not going to result in any new houses. There are a lot of people in this town concerned about new houses, but we're talking about existing houses and improving the situation from every angle with respect to those existing houses in terms of the future of the town. Nor do these amendments introduce any new flexibility or liberality in how the current zoning ordinance has been dealing with these issues. The problem is that we've got a McLeod case that made a loud sound, trumpet sound, and everyone is concerned about the implications of that. The McLeod case only has to do with dimensional variances, lots in which people would have been seeking dimensional variances forever in this town and in Westerly and everywhere else where they're trying to correct their ordinances or clarify them to conform to this case. Dimensional relief. But this ordinance already provided avenues for applicants who don't need variances and who only have dimensional issues, as long as those dimensional nonconformities are not exacerbated. Now that language, unfortunately, was stuck in the use language, so it's confusing as to how it applies. In our case, the zoning board unanimously, as to all 5 of these structures, made a decision on an appeal here that this type of development, relocating a building, but not resulting in any increased dimensional nonconformity and not involving any type of nonconforming use, just dimensional. That language is already here. Mr. McGreen has taken it from one place, put it to another for clarity, but that language was the basis for the decision in our case that there is no relief required here. There's no special use permit requirement, there's no dimensional variance requirement, but there is a requirement under the overlay district for a special use permit. And if the situation is benign enough, the ordinance provides that staff approvals can accomplish those approvals under the overlay zones. So we've had for years staff approvals for each of these projects. We've renewed them, they're in place. We've gone and gotten CRMC permitting years ago for all of these buildings. They've been renewed, they're in place. We've developed the land condominium for these 6 units. The town has signed off on the development plan. The condominium plan is not requiring any zoning relief or planning relief. The building officials have consistently issued certifications to CRMC and DEM, which is CRMC gets the certifications that this configuration doesn't require any zoning board relief or planning board relief, that these are acceptable changes for this type of benign dimensional nonconformity that's not getting any greater. And I suspect that there are many other projects that have gotten approvals that way that may not have houses on them yet, but that are somewhere in this system. They may be before staff for a modified staff approval, which is our current posture at this time. That'll actually eliminate one of these buildings and make our situation even less non-dimensionally conforming. The only non-conformity we have is that we have 6 units on 67 acres, more than one dwelling per lot. That's the only non-conformity. But unfortunately, all of these projects and people that aren't even here and people that may not even know what are happening are affected by this and may be for a long time without some kind of correction. What Mr. McGreen has put together we made a contribution on adding special use permits and staff approvals to dimensional variances to make it match what we have right now, but to also provide the clarification that's desired in order for the zoning board to continue to do its business and for the planning staff to continue to do its business. And it's very constructive, and I think the language covers everything. I had suggested some words to the effect that nothing in this ordinance shall be deemed to abridge any rights existing under existing zoning board decisions, staff approvals or special use permits, so someone doesn't have to go back to the beginning and do this thing all over again after all these years. I mean, some of these units have been sold and negotiated to be sold in this development to people who own them now, and presumably they may have to start all over again and may not be able to build on their lots, and that would be the height of injustice. I don't believe that that's what was ever intended, and I would strongly encourage the board to recommend that this amendment as constructed, I prefer the additional language about nothing abridging prior zoning approvals. It may be that the language that Jack has put together with the contributions of others may kind of take care of that, since it would make it clear that the rules are not changing. There's not going to be a sea change of regulation here, which is what I believe is the spirit of the amendment and the spirit of the group that's trying. Not make it any easier for anybody, but just not make it a lot harder for anybody and put the whole development community in chaos for years upon years and invite all kinds of litigation. This is a reasonable step. I wouldn't consider it really a compromise, because we're not changing the ordinance. We're simply clarifying the intent that has always been there, principally using all of the language that's already been there, but adding the special use permit concept and staff approval concept as something that is not going out and being somehow eliminated by this Westerly case, which doesn't appear to have been the intent of Westerly any more than this would be the intent of Narragansett over the years, and they're in the process of correcting their own ordinance in view of that Supreme Court case. Again, thank you for your attention, and be happy to answer any questions you may have of me.
Thank you, Counselor.
I guess my question is both for Mr. Landry and our council, that I wouldn't want to do anything that would jeopardize an existing approval, but how would this play out, Bob, with the vesting of the previous approvals? Would this modification shouldn't change any vesting?
No.
Or are you worried about approvals that might otherwise expire?
Well, it wouldn't involve the vesting of approvals, but we've got a zoning board. There are decisions that haven't been appealed that have almost a permanent vesting. If you have a zoning board declaration that this is how the zoning ordinance is interpreted with respect to your project, I'm comfortable about that, but that's not good enough in this chaotic environment to make the powers that be start issuing permits. People are unclear as to what the intent of the ordinance was and whether it's sufficiently clearly expressed. So even though I think most people here would feel that our project shouldn't be affected by this in any way, it is, because people, the zoning board, the building official, the planning department, are all very courteously saying, we don't really know what this means, and we need to all be on the same page as to how our ordinance will continue to be interpreted. So I think if you cut some of these things short and don't fill the circle of affected constituencies, you're leaving something out, and the other shoe will drop. I mean, how is the building official gonna issue a building permit? Or how clear is it gonna be to him that he should issue a building permit based on a decision that was made in 2022 and all kinds of other permits, where there is some confusion about how the Westerly case impacts us. This is an opportunity for the town to clarify that they're not making a sea change in anything, just trying to have things move along the way that they've moved along forever when it comes to non-conforming development, but to have an understandable set of rules that apply to the types of projects that routinely come before these boards. Projects that are already operating under permits, projects that are in the design stage, projects that have some of the permits, but not building permits yet. It's a long continuum with dozens of projects that are potentially impacted by this confusion. And that's why I think it is, and I don't think the town has anything to lose by having a few more words that says nothing's meant to abridge. We're not asking anyone to create any more rights than were created under existing approvals that have not been appealed and that are out there and that have guided the development of properties for years, just that they not be taken away from them. And if there is a vesting period, we're not asking for vesting periods to be extended, only that those approvals that are existing aren't somehow taken away from the applicants.
Steve?
So, let's presume for a second that I like Jack's newest proposal that we just got.
Yeah.
You've got that piece under 9.1 and you've added a 5.
Correct.
If we went with making it now a 9.2 and breaking it out this way, where would you want to see that ideally located? Because I'm with you. It's belt and suspenders. I prefer to have our zoning ordinance have as few words as humanly possible, but I understand your concern, and in this case, I might be in favor, but I'd like to know where you'd stick it.
I'm fine with Jack's language, but I think we would stick in, even if we had to call it a 9.3, the additional language we proposed, that nothing in this section 9 or in section 10 below shall be deemed to abridge or otherwise adversely affect rights and or approvals established under prior zoning board decisions, special use permits, or staff approvals. I think it's probably, it could be a 9.3, or it could be stated over again at the end of 9.1 and 9.2. The most economical approach, and the one that I suggested, was that both sections be addressed the same way in that. I had, after section 9 and before section 10,
That makes sense, yeah.
9.15, and whether that stays at 9.1, I think it probably should come
Down into 9.2, like
down into
9.24.
9.2, but, the same rule would apply to you. I don't really care about use variances, because my project didn't have one, but I don't want to take away from anybody else or have this interpreted. Someone else who's got a non-conforming use if another Twin Willows were to come in, I would want the same rules that applied there to apply here, not any greater or less. That involved a non-conforming use as opposed to a non-conforming dimension. And they shouldn't go backwards under the ordinance any more than anyone else. So I think it really ought to apply to all of 9 and to 10.
Okay, good?
Yeah, I'm good.
Doc? Good. Just one follow-up question to Steve's question. Jack, did you say in your presentation that you weren't sure whether it now belongs in 9-2 or back in someplace else, and based on a conversation that you had with the gentleman sitting behind you?
Oh, there he is. I'll let Steve come up and comment, but
Okay.
you weren't here when,
I was, rather than listening to music, I was listening to you guys.
Oh, you
coming
were?
around on YouTube, yeah.
okay.
Yeah, so Stephen suggested that the language I removed from 9.1 and dropped it down as 9.2 also be included in section 9.1. And just following up on the previous comments, in terms of vesting, I know in the staff also mentioned that it's unclear if those applications will need to reapply should this text amendment go forward. I've already obtained a positive recommendation from this board, and now I'm before the zoning board. I would hope that I wouldn't have to come back and do the dog and pony show again before the planning board just because of this text amendment. That seems to me would be a waste of time, and will put me back probably another 2 months. So if we're going to craft some language that would prevent people that are vested from coming back, I would hope we could also craft some language and throw it in there if we think that, Bob thinks that we would have to reapply, or Jill thinks we have to reapply. I'd rather avoid having to go back to the planning board and start from square one.
Do you think Mr. Landry's language does that, fixes that?
As long as I think he just said zoning decisions. If he also said planning recommendations, planning, if we included planning in there as well. So I wouldn't have to go back before the planning board.
Yeah, because I think when I read the judge's decision, I think there's a footnote in there saying, as the date of the ordinance would imply you have to go back and start over again.
Unless we would put some language in the
Right,
ordinance.
right, yeah.
That would.
No, I don't disagree with your point.
Thank you, Jack.
Excuse me, Jack, one question. You were talking about adding the word planning, but is there a way just to word it to be approvals? Because besides planning and zoning, you might add other considerations, say.
Recommendations, this is just a recommendation. So when you go to planning, it's a recommendation that the application is in conformance with the comprehensive plan.
But to not take away any previous rights or approvals, whether it was a recommendation from historical that involved the property that needed the
Right.
relief.
Yeah. Is there a better way you can just
The word recommendation.
tie it all up tight,
Well,
get them all in there?
Without specifically referring to a board.
I'm sure Bob could come up with some language.
Bob, all the
Yeah, I'd
pressures
give
on
both
you.
of you the instructions to go on the hallway.
Okay, Jack. Thank you, Mr. Landry, appreciate it.
Thank you.
Someone else would like to speak on this?
Yeah, go ahead.
Good evening, Attorney Matthew Landry. Apologize, you have to listen to two Landrys in the same evening, so I'll keep it short. I agree with everything that's already been said. Obviously, this is a step in the right direction to provide some clarity to the chaos, as I think my father put it. My interest is in particular the commercial uses. I have a client that's had a couple of projects pending in the queue that have been stalled until this clarity, we get this clarity as to nonconformities. Some of the language that's been suggested, I apologize, Jack, I just looked at this for the first time tonight. There's some language in 9.2 subparagraph 1 that seems to limit the ability to seek relief for dimensional nonconformities to single-family residential zones. I don't want to foreclose the opportunity for existing commercial structures that may be non-conforming by dimension to potentially seek an enlargement of a structure that may be existing. My client in particular is pursuing a demo rebuild of a commercial structure, and I think the paragraphs dealing with demo and rebuild apply to residential and commercial. The Westerly case seemed to be limited to residential, but it dealt with the ordinance language. I just don't want to foreclose any opportunities while we're in the middle of this process that we allow any structure that's non-conforming by dimension to seek the appropriate dimensional relief for any enlargements, where appropriate. So with respect to the language that's proposed at 9.2 subparagraph 1, it says in single-family residential zones seeking an enlargement or improvement of a dwelling. I would just suggest that we modify that language to encompass, commercial structures or any non-conforming structures, if that makes sense. And I speak on that limited basis just because I have a client with commercial properties and just want to make sure that gets covered. So everything else we're in agreement with, and certainly provide additional comments. But again, I appreciate the efforts, and I echo my colleagues' comments tonight. So thank you.
Next. Welcome back, Steve.
Thank
Good
you.
to see you.
Steve Marcello, offices at 70 Jefferson Boulevard. I apologize in advance for not getting something in writing to you. As many of you know, my year was up on Thursday, and I didn't want to drop a letter on you guys on Friday. I did email Jack immediately, upon seeing this, and he did make some changes. But as far as, I also have a client in the queue. I also know of a couple other people in the queue, so, obviously, hopefully, we can all work together to move this as quickly as possible. As Jack may have said, I was listening to you on the way down, although Jack had changed, moved the dimensional section to another section, I would ask that we keep the language in the non-conforming use section, as Bill had said, to encompass entities like the Willows and other non-conforming uses that may want to expand. They should also have the right to seek relief, whether it's special use permit, dimensional, or staff review. The second thing which I would like to be added is if you go to section 9.12, and then you go to the section that allows for a non-conforming building or structure damaged by fire to be rebuilt. And then it has A through G as criteria. I would suggest that we also add similar language that is at the end of 9.12, non-conforming structures that Bill had added, where it says, which includes the right to seek dimensional variances, modifications, special use permits, or staff approvals as applicable, because not only the McLeod case, but the last 5 cases that have come out of Superior Court, especially Judge Lamphere, they seem to be, I'm calling it, Jack laughed at me, I call it strict scrutiny, but it's almost strict review of the ordinance. And, the courts are saying, and I quote, it's also time that we must presume that the drafters intended every word of the ordinance to have a useful purpose and to have full force and effect. So if we do not add, or if the language isn't added to that subsection as number H, if you had a structure that was demolished by fire, you wouldn't be able to seek relief. If you knocked it down, you'd be able to seek relief. But there's no, in that subsection where it's non-voluntary demolition, there's no, there's no language allowing relief to be sought. So I would respectfully suggest that we add it to that section. It may be belts and suspenders, but I'm looking at it as if you represent an applicant, that applicant should be able to come to planning board, zoning board, and seek relief under the ordinance and not be essentially blown out by a procedural and especially in this case, it would be because of fire or flood, or where their building would have been destroyed involuntarily. So I would suggest that that language be added there. And if I may, while the last couple of court cases have noticed that, especially Judge Lamphere in the Willows case and in the Province case, have basically said that you have to reapply. You would ask that question. I would suggest or argue that in this case you would not have to reapply. The reapplication language, I think, would be applicable if the dimensional standards or the special use standards were being changed. And that would make sense if side yards were shrunken or height was higher or lower or whatever, then at that point it would make sense to reapply, because then the staff would have to review. You would have a different dimension, you would have a different standard or a different dimension in order to view the project. And then the zoning board would obviously have that new dimension in order to make their decision. In this case, none of the criteria are changing. I would say that as Bill said, all we're doing is codifying what has been done for the last 30 years, but there would be no change in the review by the planning department, by the planning board, or by the zoning board for any of the dimensions or any of the special use criteria. So there would be no practical or legal reason to reapply, because none of the dimensions are changing and none of the review standards are changing. All you're doing is allowing the applicant to request whatever relief that they are. Now, that's entirely up to Bob, whether the town makes 30, 40 people reapply. I mean, if my client has to, we will. But it just seems, it would be my argument that in this case, reapplication, having the process go through the town departments again, has no legal value, it has no practical value, but it also has no legal value, because none of the review criteria are changing, just allowing that. Other than that, I think I had emailed Jack everything else, and I appreciate what Jack had done, is doing, because as Bill said, this is affecting real people and doing regular, normal projects. So I appreciate your time, and I'll certainly be involved if Jack needs me to. Thank you.
Any other questions for Mr. Marcel? Anybody?
So the same question I had for Jack, Steve. So when I read this structure, this ordinance, the way it's written, it seems like when it was written, 40, 45 years ago, that it was pretty intentional to have the strict standards they did. And I'm just wondering if you have any thoughts of why that might have been.
Well, I was always taught in law school is that you could ask for relief from anything, whether it was a use standard or a dimensional standard. That was a use variance. You could ask for it. Obviously you could never reach the standard, but you could certainly ask for it. I find it hard to believe that while the language was intentionally written, that the drafters, and I blamed it on Taft and McSally, because they were...
and the planning boards and the council back then.
Yeah, I can't believe that there was no ability at all to seek relief. For instance, in the Willows case, at the end, Judge Lamphere said, well, you can only go to 25% and anything else is prohibited. So I thought that if it was above 25%, it would be a use variance. But the way that his opinion was, if it's above 25%, you can never ask for relief. I don't necessarily agree with that, but again, although it might have been written intentionally, the ordinance was drafted, the zoning ordinance was drafted as a whole, and it did allow for both use variances and dimensional variances in other sections. So I would say that the other sections didn't exclude section 9.1, so it did allow for relief, and I would think that this does not go against the spirit of the original ordinance, because again, you're not lowering any standards. They still have to meet any standards before either this board, if it's unified development, or the zoning board. But given the fact that this issue has not come up in the last 35 years, that people have sought relief, leads me to believe that some type of relief, even if it was a use variance, which in some cases it would have been, that relief would have always been contemplated at some point.
Thank you, Mr. Marcello. Is there anyone else here tonight who would like to speak on this matter?
Gail Halleck, architect, Gail Halleck Architects Incorporated, Gail's here. Thank you, everybody. I know you've all been working on this. I appreciate the lawyers for all the language you're working on and creating, and I know the planning department has been working very hard to create a great new set of wording for the ordinance, and also for you for considering this. I'm here because I've got 7 clients out of my tiny practice who have been affected by this. And I have a couple of them sitting here. I have at least 3 in Breakwater Village who've already gotten their planning department and their zoning variances. And they were before Wayne, you know, and then Wayne found out about this Supreme Court decision, and, you know, well, we stopped because we have to wait and make sure that, you know, what they build can stay up. So, you know, it's all totally understandable. But what I'm arguing here for is, yes, if they've already got the approval, can we just not go back and do another couple of months worth of you know, approvals? If we could get it done quickly. I know one of my clients was going to build in the fall, and that has already gone by. The builders that I know they're losing money. They don't have the clients lined up, and all of a sudden they've got to, you know, reschedule and find some new clients to build until we find out what's going on. If we have to all of a sudden redesign these houses, you know, the Breakwater Village houses are tiny. We're going to have to make them even smaller, and that's kind of constrictive on something that's already been constrictive. And sort of the way I see it is, you know, up until 2023, we had a very well-considered size restriction on the lots in Breakwater Village and the lots in Narragansett. People worked very hard on it in 2021. We got that. It was, you know, it was all doable. It was great. Then in 2023, all of a sudden, you know, we had this, well, okay, we're all allowed to have now this adjustment of 15%, you know, either the side, you know, yard setbacks get, they were restricted, and then we understood that 15% could be added back in, so that would work. We also understood that the houses were, you know, made to be smaller, but that we had this understanding that the 15% would be added back in. And so, you know, the houses, when I was designing them, I was designing them to be, you know, the 15% less that was called for after 2023, but then I would add the 15% back into the houses, so they got back basically to the original 2021 dimensions, which, you know, seemed logical. You know, the Breakwater Village houses were small and they kept the village looking pretty, but it was all doable. Now if I have to take that 15% back out of those houses, and make them small again, smaller than they, you know, they were required to be earlier, it's restrictive to my clients. It's like just overly restrictive to having a house built at that. And I know I don't speak as well as these people. I'm a drawer. I draw beautifully, but I don't speak. But you can hear the passion in my voice. It's so frustrating because I've got clients who are in the design process or stopped. We don't know what to do. I've got clients who are about to be built. We don't know what to do. So I'm just hoping for speed. And thank you very much, everybody, for doing all of this. So.
Anybody have any questions?
Just a comment. So I looked at the data of variance and special use permits over 5 years. 15% of them came from Breakwater Village.
Wow.
Yeah.
A lot of them were probably my clients.
Right.
Thank you, Ms. Allen. Anybody else? Mr. Ferrandi?
Thank you. Thank you, planning board members. I'm gonna bring a little levity into this whole thing. I've never seen.
You have to identify yourself to the audience.
Oh, I'm sorry, Steve Ferrandi, 44 Sylvan Road.
Sure.
Narragansett. I guess to get as many attorneys as we have here in a tizzy, it's got to be one hell of a good decision by the Supreme Court. That's one way of looking at it. Maybe the attorneys might not see it that way, but and maybe there were other interpretations of the forefathers that had this ordinance, where they wanted it to be rebuilt the way it was. They wanted to see the neighborhood culture stay somewhat the same. But it looks like that the Supreme Court decision even solidifies your existing ordinance, and it almost forces the town to go by these. I guess what I didn't realize that, because I had it happen to me across the street for me, I had a knockdown in a big 8-bedroom, someone was going to redo it, and I didn't realize that there was an ordinance saying they weren't going to be able to do that unless they put the same thing. So why is the town not being enforcing their own ordinance for all these years? That's a question, I guess, for the town staff, but so I just see this as solidifying what's already existing. Now I realize that it puts everybody in a tizzy because for all this time, we're able to say, I want to knock it down. Okay, if the planning boards or the commissions were conforming to the strict use of this, they wouldn't be able to do this. So now it just, maybe the Supreme Court looked at it and says, well, I'm just going by the letter of your law to the ordinance. But because things are done by tradition maybe, and not so much what should have been done, this is what we get. So we get a place where if someone wanted to knock down the house, they would just say, okay, immediately because of our comp plan, which enter into as I understand it, but would be allowed to knock it down and put whatever they want, go for the variances. So we got used to that. Now, was our getting used to that correct? Maybe it wasn't in this case. You know, we've had a lot of the tear downs and knockdowns. People are very worried about that. The Crane report mentioned some of the housing problems we have, and there's no guarantee that these, we're trying to get, we're losing elderly people, we're losing younger people that can't afford it. Maybe the forefathers saw this before and looked at it like this could be a good growth development for more residents and more younger people to get here. Now you're gonna, if they solidify it even more, and it looks like there's a brand new ordinance already from what I read, that what they wanted from before, so it's a little bit I think it's a little bit too soon to be going through this whole ordinance, although I realize they're trying to, straighten it out. So I just think that some deference should come to, and this could be taken as a workaround for our existing ordinances, so it has to be changed. So I mean, there's some things to think about that the town maybe was not doing the right thing by allowing the knockdowns and the variances. We should be thinking about that before we jump to say, well, why is it such a bad decision by the Supreme Court? They only really read the letter of the law on the ordinance and then put it out there that this is what it has to be restricted by. Rupert's been asking some questions about that, what the strictness are, and I think that all should come down to it. Now, if you want to, look at some variances or whatever it is, and an existing structure is different than an empty lot. An empty lot is an empty lot, they're two different entities. An existing structure was there, okay? And it's not, it's not taking someone's rights away, they can rebuild that somehow. If they wanna keep it the same, they can rebuild it. Now, maybe there could be some additions to that, to help that, but I just don't think this other ordinance that you had was being enforced the way it should have been. And, you know, why are you jumping to just correct everything, because a lot of people are in the pipeline? What about the people that, maybe they knocked it down, or they didn't, they built exactly what they had to, because they wanted to. Anyway, I just think there's a lot of questions more than anything in this, and I don't think it's good for the town, for the character of the town, that, you know, we might see an increase in these tear downs. Now, if I would have known that back in my neighborhood, when the person tore it down and put an 8-bedroom home, that they shouldn't even have allowed to change it, it should have been the same cottage, how do I feel? How do the residents in Narragansett feel about this? I mean, this is what's happening in this town, and I understand the lawyers are involved, and the zoning is very complicated and everything else. I try to understand it, it's very difficult. But, you know, we have to listen to that and look what this might do for the town with more tear downs, if it's wide open. And then you're gonna someone's gonna have to write an ordinance. Well, that new ordinance coming in has to have protections in it too, to go beyond it. So that's all I have to say. It's kind of a resident's point of view. I realize that people wanna come into the town and they wanna build their homes, I understand that. But it's not just about everybody else's, it's everybody else's idea of what they wanna do with their house that they purchased or their lot. I understand that. We're individual here, it's America. But, you know, we have to give some deference to the community as a whole. What are gonna be the consequences? So that's all I'd ask. Thank you.
Yeah, Mr. Friend, you said the house right in your neighborhood got knocked down and they built a much larger structure than was there before.
Right.
Did you, once you saw that was going, did you check with the building inspector to
Yeah,
make
we
sure
did.
the dimensions,
We did,
the
but I mean,
sides, the look?
Yeah, I think we did all that, but I mean, the way the letter of the law reads now is it looks like you have to build it exactly like it was, and it was always that way. It was just that, maybe it's, I don't wanna say it's the staff, but it was just the town by tradition that never followed that ordinance. And now that the state said, well, you have to follow your ordinance. I mean, anybody can correct me if I'm wrong. If I'm saying the wrong thing, please, the attorney's in the room, anybody. I'm not trying to make it up here like I know exactly every detail of what's going on.
And then,
You know, if that's a possibility, I'm sorry.
and your neighbor didn't get exception, come through these boards to do
No,
what they
he
did?
did not. He
They
did
didn't,
not.
they just built it, okay.
Right, it conformed to whatever was there, you know, he put it out in the lot. But at that point, there was no bulk zoning or anything like that. And then other times, you know, and half the time the people get involved in this and they say, okay, they go for you allow them to get the permit, they say they're not gonna knock it down, then they find out they can't build on it. Why doesn't some of that review go before, if it's a possibility, if it can, I mean, how much does it cost for an engineer if you give it a set of plans to see if you can build on the same foundation? Some of it could be saved rather than just throw everything out and scrap it, and I have to have something new. I realize life changes, you know, people need more room and all that. But you've got a lot of smaller lots that this is gonna affect. Maybe the more critical lots, that's gonna change the neighborhood character of this town. And it already has already. And you know, if I knew what I knew now about being not able to really do this in the beginning, and trying to fix other lots, if we would have been enforcing this before, we might have had some cottages that got a little bit bigger, stayed on the same footprint.
I got it. Steve, do you know if they asked for any dimensional relief, a variance, your neighbor?
I'm not sure what they asked for.
All right, because
if that was-
originally you said they did. And I just want to make clear to you.
Right, but.
This doesn't say that you have to rebuild it as it is. It says you can't ask for dimensional relief. So if they didn't need dimensional relief and they just built to the setbacks, this wouldn't have stopped them from doing that. Just so you know.
But what I'm saying is, according to what it seems like, they disregarded that, and a lot of them that tore down the house asked for dimensional relief.
Yes, that was So,
And they didn't keep
45
it the
years
same.
ago when they
Now
wrote it,
this one says
those
you
people
can't ask
didn't
for
die,
dimensional relief.
right?
There's
They
two-
were here.
There's two distinctions in this ordinance. This one says you can't ask for any relief at all.
Yeah.
That's what I'm getting at. So if we know everybody coming in with the permit is gonna go from what was there, then fine, you know that's not
But
gonna happen.
that's not what relief is, Steve. Relief is relief from the dimensional regulations. So they can build a bigger house as long as they don't
No,
need
no,
dimensional
right,
relief.
Right, I understand.
I-
They
well, I
have to
just
stay
want-
in, they have to stay in the height and all of that stuff, right? I understand.
Of the dimensional
And the
regulations,
size.
not of the building that exists.
And a lot
I
of
wanna make
times, some
clear
of
that.
these may be closer to the, they're already non-conforming, a lot of them, so you have
Yeah.
to stay within that.
Well, you don't have to stay with that, that's still proper. We've been treating it as though if you're already non-conforming, then you can ask for a variance to remain dimensionally non-conforming. But what this is saying, what the judge said is, you gotta read it exactly as it's written.
Right.
And it says you can't ask for those dimensional relief, but the building can still get bigger, Steve, as long as it's within the dimensional regulations.
Well,
If you're-
I think Steve, it's a little,
I don't wanna get in the back and forth, leave it for the lawyers, but
I think it's even a little bit more nuanced than that, because if it's non-conforming, it can't get any more non-conforming, it can get bigger.
Right.
yeah.
It can get bigger, it can grow, but you can't increase the non-conformance, as I understand what's required. So,
That was my point. Anybody?
anything else, Steve?
No, that's fine.
Anything else for Mr. Ferrandi?
No, I'm good.
Okay.
Thank you.
Anyone else here want to speak on this?
Hi, Peter Suska, 15 Tellier Road, which is part of Breakwater Village. I just want to speak for myself and some of the other folks at Breakwater Village. And I'd like to start off, because I've never had a chance to say this, how nice it is to run through this process in Narragansett. I mean, nice system, nice people, the responsiveness is incredible. It's really a great system. Thank you. I don't want to say anything negative here. Hopefully I'm not. But we're frozen like a lot of other folks are, and we, I guess, would like to make sure that with all the work that Gail's done and everybody else has done, that we are able to stick with what we have already designed, not to have to go back and go through the process again. All of that, I think, is just all we're asking for, and I think you all talked about it in terms of whatever you can do to expedite this process, we would love. Because there's a whole, it's not just us, it's the whole supply chain behind us that's being affected, right? It's not just the builder, it's all the subcontractors, it's everything. And once you bump that back, it's hard to get it going again, like we would plan it to be. So that's all I wanted to say. Thank you all for what you do. I appreciate it. I know this is all volunteer. Thank you.
Thank you, Mr. Suska.
Whoa.
Anybody else? Okay, do you have any closing remarks you want to make, Jack?
No, I'm good to go. I did appreciate the comments from that architect that pointed out about the 15%. Because when you think about it, if we weren't going to do this, everyone thinks you get the 15%. So now you're really restricting those people if you don't get rid of that, if you don't bring back your dimensional setbacks to what they previously were. You would have to do one or the other. So if you're not going to change this, you would at least have to do that, get rid of the dimensional. So, especially in Breakwater Village, I mean, taking away another 15% and they can't ask for relief. And just the final point again is, if you have a lot here that's vacant and you have a house that's falling apart, the vacant lot person can ask for dimensional release, but the house that's falling down that really should be taken down can't ask for dimensional release. Just from a practical point of view, it makes absolutely no sense. Thank you.
Thank you. Okay, so we started down this path as a result of wanting to hear from the other attorneys that were here and other folks that were here to, I'll say testify, comment on the proposal. We, at that moment in time, were thinking about a couple of different things. Subcommittee, come back and have or go back and have a regular meeting. I'm not sure in people's minds how much of that became clear as a result of the discussion that we had, but here's a couple of thoughts that I'll share from my vantage point, it seems to me that we don't have a actionable document in front of us right now, number one. So we can't act tonight, number one. Number two, we're gonna need, if you're willing to do so, Jack, some relief on our end from the clock that's ticking right now in terms of getting a recommendation to the town council. It seems to me it would be useful, that rather than at least forming a subcommittee at the outset, is for the proponents who would like to who have, who want to change this, is to get together and get a single document for us to consider, and to get it to us timely, and get it to us timely, so that then maybe a subcommittee then can be formed, or can be formed now to basically look at that document, work with staff and council, and come back and have our next discussion about this item. That's kind of how I see it. Others might have a different approach, but that's kind of how I see it.
I saw really just three, what I consider to be somewhat minor suggestions that came out of this. One was section 9.12, adding with an H, which added the ability to seek relief in a act of God or fire, or any type of involuntary demolition. The other comment in section 9.21 was the possibility of removing in single-family residential zone and making it to any structure to allow commercial properties to have the ability to seek this relief. And then the possibility of adding a section 9.3, which was Attorney Landry's, I'm going to call it his vesting clause, or protective of previously granted approvals. You know, the only concern I really had looking at this, I think that the recommendations were well thought out and well written, but I would like to see staff and council have some time. I don't know how much time, because it isn't that much that changed. So I mean, I'd be open to, I know we have a meeting next week, even if we had a special, I don't know procedurally what people's availability is, but the following week to still be able to possibly get this to the council by their February meeting, if that gives enough time.
The deadline for this is January 22nd to go to council. We could theoretically do it, I believe the public hearing with the council is February 2nd. We could possibly get it to them beforehand, before that. I don't know, I'd have to refer to legal if we could do that.
Jack and I were just talking, if we could make one suggestion, is this is a major amendment. It might be better if all of us could get a document to the town, so Bob and Jill and Wayne could review it. However, it seems like the best, most efficient way would be to have the town council open their public hearing on the 2nd, and we could then submit an amendment, which would be a full amendment. Since the amendment is a major change, it would have to come back to the planning board. So then you could have your meeting after the 2nd, because otherwise if you have a document here that's been referred by the town council and it really can't be changed, it has to be changed at the hearing level.
It's not been referred by the council.
And then referred back.
But I'm not sure, Steve, it's actually been referred by the council, came directly to the planning board.
But the town, in order to, the amendment though, in other words, we have the public hearing is opened on the 2nd. And then since it's a major change, it would have to get sent back here.
So what are you suggesting that the action that this board would or would not take this evening?
Have the meeting after the town council meeting on the 2nd, rather than before. That way, any amendment would be encompassed.
Have the follow-up meeting for this?
Because if Mr. Callahan or Mr. Craven, who's ever there that night, says it's a major change, it has to get sent back. If it's a minor change, you can move forward.
Okay. What I'm missing from what you're suggesting, Steve, there may be others here who...
Yeah.
who can clear it up for me. We've got something in front of us right now that has to be, as I understand it, acted upon by the 22nd of January. Unless we get some kind of relief from from Mr. McGrane. Because what you're suggesting is then we not act by the 22nd and wait for this to be sent as a revised major amendment to the council and then come back to us in that form?
I mean, you certainly, I'll leave that up to Bob, as far as acting on, the only thing you have before you is the original submission.
I was gonna ask.
So, and I'll leave it up to Bob.
Yeah, I was gonna ask that process of council. I mean, when we had amendments come before us from council, we were told we had a vote up, vote down decision on it. I don't know if this is the same because it's coming from an applicant. And I don't know if we can redline this and send it to council. It's like,
I'm not sure exactly what we're gonna vote on if we voted on tonight.
Correct.
That makes me very nervous to send a document to the town council saying we somehow approve of this when we really don't know exactly what it is. This exercise with these three gentlemen over here, with collectively over 100 years of knowledge on zoning law, would be great for this body to have the benefit of the concerns, the debate, and then a work product that comes from that. The methodology that Steve is referring to would be, you know, the town council is going to have it on its agenda on the 2nd, but it wouldn't have received a recommendation up or down from us. It would go absent that process that causes it to go there. I don't know, are you guys willing to waive that?
Yeah.
Well, if it's waived and you give us the time, I'm comfortable going forward. They're the interested parties, and it's their amendment.
And so we would be going forward doing what, Bob?
We would go forward saying we're not gonna make any recommendations, we're operating under the presumption that when it reaches the town council, there will be a major amendment submitted that night to the town council, which would then have me be asked, or James Callahan to be asked, is this a major amendment? Yes, we gotta send it back to the planning board. And then whether you have a meeting and discuss it and vote on it, or whether you have a work session, or whether you have a committee that will discuss it, that's your decision at that time, once we've all seen, because I'm pretty sure you guys are talking about a matter of days, not weeks, to
We could
produce
probably
a
get
document.
something revised and out by Friday.
There you go. So we'll all have it, and we'll all know.
So would the action, seems that we have two potential actions, there may be more. One is to essentially have the applicant withdraw and then resubmit, or have
I'm
us.
just gonna waive the time requirement.
That's what he's looking, that's what we need, to waive the time requirement, so we won't
Get
be
jammed up.
forced to act, or have acted in the absence of acting.
Okay. And do we need a waiver to a date certain, or just a waiver?
We should be talking about, it'll go to the town council, which will then be on the 2nd. They'll send it back to us, and I don't know if we've got a clear idea of when the meeting would be thereafter, so we can preserve notice if you wish.
Well, would it have to be re-advertised in the paper?
Wouldn't
If it's
be
a major amendment?
I think you can do it if you can not have to re-advertise, if it's a date certain that we pick right now. And that notice is gonna go out from this place to all seeing and hearing about it, that we'll be back on our agenda on sometime.
I mean for the town council. Does the town council have to re-advertise when Mr. McGreen walks in on February 2nd and hands them a major amendment? Does that have to be re-advertised in the paper? Because that will dictate what the time frame is. If that's the case, then it will be at least 3 weeks out from that point.
That's the safest way, that's the
Okay, so then then that would essentially put them to the first meeting in March.
Well, I mean, I can make an argument that it's not a major amendment because all we're doing is clarifying the language I already asked for. All I'm asking for is permitting dimensional relief, allow someone to get dimensional relief on a legal non-conforming lot. That idea has not changed. Some of the words have changed, so I would argue that it's not a major amendment.
That's an argument or a discussion that the lawyers and myself can have to say, what will the solicitor tell the town council at that time as to the nature of this?
And if we're before the town council in an open meeting and we're talking about the amendments, wouldn't that prevent the need to re-advertise, even if it was a major amendment?
I defer to the solicitor who's sitting next to me on that one, whether it's substantive or not. I mean, I've seen them not send things back to the planning board when they've been deemed minor amendments, but the real, Mr. McGood, the reason why I ask is not for the advertising purpose. If it needed to be re-advertised, that's an automatic 3 weeks out from the date, from February 2nd or whatever day it goes. So that's, this started off about what the timeline is. That would dictate your timeline. That would put you to the first March meeting because you wouldn't make the February meeting, the second February meeting. We can't ask council to have a special meeting. This board may be able to do that in a, they may be more flexible.
Turn that around a little quicker than Friday, Jack? I won't put the heat on you, but if I'm gonna ask for a special meeting and put the heat on everybody else, let's get cooking.
Wednesday? Yeah, Wednesday?
Yeah, if you can get it back
No.
to no? No.
We have a meeting on Wednesday already.
No, I don't mean for, I mean them getting it back
Oh.
to you, so we could sneak in a special meeting before the town council meeting. Sorry, Joe. That's where because we're just clarifying the language that we've been, to clarify this as we've been using the zoning ordinance for 45 years. Nobody said we shouldn't be doing this in 45 years. It seems like an easy amendment. If you guys get your heads together, we get it cleared. I think we can do it, but I don't know our schedule, so that'd be up to you, Joe. That's why I'm asking.
What would be the benefit of that? Can I ask?
Because the benefit would be if we could turn it around before it goes to the town council, we could give them a recommendation and then they could just
Mr.
approve it.
McGreen, if you had it to us by Wednesday, this board would still need to have a special meeting. Is that what
Yes.
we're getting at?
Yes.
Depends on when the special meeting is.
Anytime is good for you. Based on if you got it back, that's what I'm trying to figure out, because
Right.
I don't want to shove a bunch more work on you, but if we can get it done by the 2nd, it seems better.
So I don't think logistically we'll be able to get anything done by the 2nd. So next week, staff has a meeting every night of the week.
And if I can also remind you, there's a holiday next Monday.
Don't remind me that. There's too much stuff on my plate already.
Right.
You'll lose a day. Okay.
And then the
Just
week
spitball.
after, no, that's okay. I mean, we're just physically not available.
Yeah, that makes sense.
And then the week after, I believe we have a meeting on the 28th, is that correct, Heidi? And then
Yes.
Zoning is the 28th, so we'd have to check room availability and staff availability,
Yeah.
but, the day before that, maybe.
Good.
So, to back up a second, so what has been the, Joe, what has been the process for review of these? Has it been just a variance consideration for the last, whatever, 10, 15, whatever, as long as we know?
Yes.
Or has it been a special use permit or?
Well, it depends on how it comes in, Mr. Friday. So typically, single-family home, demo rebuild, variances. And the special use permits, we've been talking a lot about section 4.4, but there are other special use permits that could come into play, parking, for instance. There are other forms of relief that the ordinance addresses, which I didn't hear addressed tonight, so I can bring it up right now or with Mr. McGreen. But since Mr. Landry, Matt mentioned he wanted to have some additional language for commercial structure, there is at least one location of which I can think off the top of my head where the ordinance requires zoning board approval, but it isn't a variance and it isn't a special use permit. It's just it's an approval, and that's the way we refer to it. So I don't know if that comes into play or not. I don't know, Mr. Landry, Matt, if you looked at that at all, and one of the standards. So that's probably something, we're gonna throw everything in the wash, let's throw it all in the wash. So,
I mean, my observation is, this issue is ripe for litigation, as is evident by the Supreme Court decision. And I've been in court when the judges commented that Narragansett can't seem to get the process right, so I think it behooves us to get the process right. Anyhow, and I think it behooves us to get the product right as well as the process.
so Mr. Chairman, might I ask, was the thought that this board, it was mentioned earlier, would put together some kind of a subcommittee, receive from Mr. McGreen a revised draft, and then review that? Or is this board going to just receive the draft as an entirety?
I would like to review our counsel.
So, let's see if we can let the Gordian knot here.
Yeah, sorry.
Yeah, that's okay. Procedurally, we have something in front of us tonight, which clearly is not in shape for us to send it to the council, right? And it seems to me that the proponents need to give us something to do that. Whatever day it is, whether it's Wednesday, Friday, whatever the case may be. We need an opportunity to review it, you guys need an opportunity to review it. Then the only question becomes whether or not there's a subcommittee that meets on it, looks at it more fully of the board before we take this up at our next meeting. The issue of whether this goes to the council on the 9th or whatever that is, that seems to be a separate matter from what we need to do tonight. Am I right or am I wrong? No, I'm just saying.
Seems you covered most of it there, Tom.
Right, so I think based on what we, and I'm not, so what I would suggest is, from my vantage point, I'm not comfortable that I've seen something and had a chance to think it all the way through, have a chance to bounce it off of you all, in a organized fashion just yet. So what my recommendation would be to the board is to essentially take no action tonight, whether that's to continue or table. I will leave it to you to advise me. And then whether or not the proponents opt to go to the council in a separate fashion, if we're asked to provide a recommendation to the council, my recommendation would be the council would be, we have no recommendation because we haven't had ample time to take a look at a complete document that the proponents have prepared for us. That's kind of my position. That's where I think we should go.
I agree with you, and so the only question is for the board is, do you table it or do you
Right.
continue it to a date certain?
Right.
And we're back to the next council meeting is February 2nd, and we're looking for a date that you say the beginning of March?
If we,
Be the next
if we,
possible date?
if
no,
we-
I'm sorry.
No, I'm just asking, if we tabled it tonight, it could be listed as a matter of whole business, put on the agenda for the next, put on the agenda for the next meeting, which is next Tuesday. Excuse me, next Wednesday, excuse me. And see where we are procedurally with what we've got, in terms of whether we've got the document that these guys said that they're gonna get us, whether you all have seen an opportunity, and then for us to decide at that point in time, procedurally, how can we get to where we need to be?
I haven't seen the agenda for next Wednesday, but
But
seems like it's
old
crowded.
business would be one of the last items on the agenda.
Okay.
And it really would be not necessarily, unless we can clear it and go, it would be procedurally, how do we now take this
Yeah,
and get it ready for the
good
council?
idea. I'd suggest that.
So I'll entertain a motion to table.
So moved.
I'm sorry,
Next meeting, next Wednesday.
not to table.
To table this and put it on as a.
Don't you want to continue to a date certain because it's a public hearing? It's just,
This is not.
am I missing?
it's
I'm
not a
sorry,
public
sorry,
hearing.
sorry.
Yeah.
No, That's right, February 2nd's gotta be.
Because-
I just, the question of semantics, is it tabling or continuing?
Table.
That's table.
Okay.
And adding it as an item of old business to next Tuesday, to the Wednesday's agenda.
Wednesday.
For the purposes of nailing down the process for getting it done. Now, do we need to communicate something to the council?
Not at this moment, because you're having another meeting before the due date.
Okay, good. So I'm sorry, so there's a motion and a second?
Who seconded?
I'll second it.
All in favor?
Aye.
Opposed? Okay. So, go ahead.
Mr. Chairman, just a comment for the record. I think all of us are here believe that expediting this process is important. At least I certainly do.
Agreed. Okay, I think that is the only other item on the agenda for this evening. Motion to adjourn? Second? All right. We're adjourned. Thank you.
Aye.